The morning I woke up to find a bright orange notice stapled to the fence post at the edge of my property. I knew my peaceful life in northern Wisconsin was about to get complicated. I am Frank Sutherland, and I had lived on my 15 acres of heavily wooded land just outside Eagle River for the past 8 years. My property was perfect for what I needed: privacy, access to endless snowmobile trails, and enough distance from neighbors that I could actually breathe. The land backed up to county forest land, which connected to over 200 miles of groomed snowmobile trails. That access was the entire reason I bought this place. The notice was from the HOA. Yes, apparently when I purchased the property, there was technically an HOA associated with the development, though calling it a development was generous. There were only 12 properties total, all large acreage lots carved out of old logging land. The HOA had been dormant for years, collecting minimal dues for road maintenance and doing basically nothing else. I paid my $100 a year and never heard from them, until now. The notice, printed on expensive cardstock with an embossed header that read Pine Valley Estates Homeowners Association, informed me that effective immediately, I was prohibited from using the private access road that cut through the HOA common area to reach the county trails. The road in question was a quarter-mile stretch that connected my property to the state land. Without it, I would have to trailer my snowmobile 20 miles around to the public access point. I read the notice 3 times, my coffee getting cold in my hand. The temperature was already dropping into the teens, and we were heading into prime snowmobile season. This was not happening. The notice was signed by Patricia Morrison, HOA president. I had never heard of her. I grabbed my phone and called the number listed at the bottom. A woman answered on the second ring. Pine Valley Estates HOA, Patricia speaking. Yeah, hi, this is Frank Sutherland. I just got a notice saying I cannot use the access road anymore. What is this about, Mr. Sutherland? Her voice was clipped, nasal, the kind of tone that immediately put my teeth on edge. The board held an emergency meeting last week. We have determined that snowmobile traffic through the common area constitutes a nuisance and potential liability. The decision is final: a nuisance. I have been using that road for 8 years. It is literally the only way to access the trails from my property. That is unfortunate, but the HOA has the authority to regulate use of common areas. You should have received a copy of our updated bylaws in the mail. I did not receive anything. Well, they were sent. The vote was unanimous among the board members present. Have a good day, Mr. Sutherland. She hung up. I stood there in my kitchen staring at my phone. This could not be legal. I spent the next hour digging through my property documents, finding the original HOA declaration and bylaws. They were vague, written in the early 90s when the lots were first plotted. There was language about maintaining common areas and roads for the benefit of all owners. Nothing about restricting access. I called a lawyer friend of mine, Tom Henderson, who practiced in Rhinelander. He listened to my situation and let out a long sigh. Frank, technically, if the HOA followed proper procedure for amending bylaws and voted on it, they might have the authority. You would need to fight it, which means lawyers and time and money. Even if you win, it could take months. So what do? Go to the next board meeting. Try to talk sense into them. If that does not work, we can look at your options. The next board meeting was not for 2 weeks. By then, we would be deep into December, prime riding season. I decided I needed to understand who I was dealing with. Some research revealed that Patricia Morrison had moved into one of the Pine Valley properties about 18 months ago. She was a recent divorcee from Milwaukee, had taken a generous settlement, and apparently decided to reinvent herself as a North Woods property owner. Her house was one of the smaller lots, only 3 acres, positioned right at the entrance to the development. The access road to the trails ran directly past her property line. I drove over there that afternoon. Her house was a newer construction, out of place among the older cabins and ranch homes. It was all white siding and black shutters, very suburban, very Milwaukee. A silver Lexus SUV sat in the circular driveway. I knocked. Patricia answered, and I immediately understood the type of person I was dealing with. She was maybe 50, with an asymmetrical blonde haircut that probably cost $300, wearing athleisure where that had never seen actual athletics. Her expression when she saw me was already pursed into disapproval. "Can I help you, Mrs. Morrison? I am Frank Sutherland." We spoke on the phone. I wanted to talk about the trail access situation. "There is nothing to discuss. The decision has been made." "Can I ask why? What changed?" She crossed her arms. "Mr. Sutherland, I moved up here for peace and quiet. The noise from snowmobiles starting at dawn, racing past my property at all hours, it is unacceptable. My sleep has been disrupted. My guests complain. This is a residential community, not a recreational facility. The trails have been here longer than your house." Her eyes narrowed. "The HOA has rules. I am simply enforcing them. You just made up new rules. I am done with this conversation. If you continue to trespass on HOA property, we will take legal action." She closed the door in my face. I sat in my truck for a minute, hands gripping the steering wheel. This was personal for her. She had moved to rural Wisconsin and decided to treat it like a suburb, complete with HOA tyranny. The worst part was, she probably had no idea that most people up here owned snowmobiles, that the trails were an economic lifeline for the entire region, that winter recreation was not a nuisance but a way of life. I drove home and looked at my property maps again. The access road was the key. It was technically on a strip of land designated as common area, maintained by HOA dues. But here was the interesting part. My property had a deeded easement for access. I dug deeper into the documents. The easement was for vehicular access to my property. It did not specifically mention snowmobiles, but it did not exclude them either. More importantly, I noticed something else. The main road into Pine Valley Estates was also on common area property, and my property, with its long frontage, actually bordered that road in 2 places. One of those places was right at a narrow point, just past Patricia's house, where the road squeezed between my fence line and a steep embankment. An idea started forming. If Patricia wanted to play HOA games, I could play too. I started reading the bylaws carefully, every boring page. There it was, buried in Section 12. Any property owner could request permission to perform improvements or maintenance on common areas adjacent to their property, subject to board approval. But in cases where approval was delayed beyond 30 days, the owner could proceed with improvements that benefited their own property access, provided they did not permanently damage common infrastructure. It was a loophole, probably written in by some lawyer decades ago to prevent the HOA from blocking necessary driveway repairs. But it was there. I spent the next few days planning. The narrow section of road past Patricia's house was barely wide enough for 2 vehicles to pass. My property line came within 15 feet of the road edge. If I were to, say, decide that I needed to improve drainage on my property right at that pinch point, I could legally dig a substantial ditch. And if that ditch made the road impassable, well, that would be unfortunate timing. But I decided to try the reasonable approach first. The board meeting was at Patricia's house, because of course it was. I showed up with my property documents and a printed copy of the easement language. There were 5 board members total. Patricia was president. The vice president was a man named Douglas Crane, a retired accountant who looked like he would agree with whatever Patricia said. The secretary was Helen Porter, an older woman I had actually met before at the general store, who seemed uncomfortable with the whole situation. The other 2 members were Richard and Susan Fletcher, a couple who owned one of the larger properties on the far end of the development. We sat in Patricia's overly decorated living room, everything white and gray and utterly sterile. Patricia called the meeting to order with unnecessary formality. "We have a guest tonight. Frank Sutherland is here to discuss the trail access restriction." "Thank you for letting me speak," I said. "I want to present some information about my property easement." I laid out my documents. My deed includes a specific easement for vehicular access through the common area. This has been in place since the property was first sold in 1995. Snowmobiles are vehicles under Wisconsin law. By restricting my access, you are violating my deeded rights. Patricia barely glanced at the papers. Snowmobiles are recreational vehicles, not the same as cars or trucks. Your easement is for normal residential access. The easement does not specify that limitation. The intent is clear. Douglas nodded along. "I agree with Patricia. We need to consider the quality of life for all residents." I turned to Helen. "Mrs. Porter, you have been here longer than anyone. You know these trails are part of the community." Helen shifted uncomfortably. "I do understand, Frank. My late husband used to ride, but I also understand noise concerns. I ride responsibly. I am not racing through here at midnight. This is about one person deciding she does not like snowmobiles." Patricia's voice went ice cold. "This is about maintaining property values and community standards. Your hobby is not more important than the well-being of other residents." "My hobby?" "This is transportation. This is access to public land. You cannot just cut me off." "We can and we have. If you violate the restriction, we will fine you $100 per violation. Those fines will compound and can result in a lien on your property." I looked at Richard and Susan. "You 2 have not said anything. Do you even care about this?" Richard shrugged. "We do not use that access. It does not affect us." "It sets a precedent. What is she going to ban next?" Patricia stood. "This meeting is over. Mr. Sutherland, you need to leave." I gathered my documents. "You are making a mistake. And you are trespassing in my home. Get out." I left, my hands shaking with anger. I had tried reasonable. I had tried legal arguments. Patricia did not care. She had her little fiefdom and she was going to rule it however she wanted. That weekend, I rented a small excavator. On Monday morning, I started digging. The spot I chose was perfect. My property extended right up to the edge of the road common area at the narrowest point. I applied the concept of improving drainage, which was technically true. Water did pool there after heavy rains. The fact that my drainage improvement required a ditch 6 feet deep and 15 feet long, positioned in such a way that it made the road completely impassable, was just engineering necessity. I was careful. I put up orange safety cones. I posted proper signage about construction work. I stayed entirely on my own property, with the ditch just barely on my side of the property line. The excavation made it physically impossible for any vehicle to pass without driving into either my ditch or off the embankment on the other side. By Tuesday afternoon, I had effectively blocked the only road into Pine Valley Estates. My phone started ringing around 4 p.m. I let it go to voicemail. Patricia's voice was shrill with fury. "What the hell do you think you are doing? You have blocked the road. This is illegal." "I am calling the police." Good, I thought. Let her call the police. The sheriff's deputy showed up an hour later. His name was Mike Tomlinson, and I had met him before at the local diner. He got out of his patrol car and surveyed the situation, then walked over to where I was standing next to my fence. "Frank, what is going on here?" "Property improvement, Mike. Drainage issue." "Uh-huh. And the fact that it blocks the road, unfortunate timing." I submitted a request to the HOA for approval over 30 days ago. This was a slight exaggeration. I had submitted it 10 days ago, but I was betting Patricia would not have documented anything properly. Under the bylaws, I can proceed if they do not respond. Patricia Morrison is pretty upset. Patricia Morrison banned my snowmobile access. I am just working on my property. Mike looked at the ditch, then back at me. "This seems like a civil issue. You are on your own property, completely. And you have the documentation." I showed him the property survey and the relevant bylaw section. Mike read it, shook his head with what might have been a suppressed grin, and handed it back. "Like I said, civil issue. They will probably take you to court." "They can try." Mike left. I heard him talking to Patricia, who had come storming down the road on foot. Her voice carried across the cold air. "He is doing this deliberately. Make him fill it in. Madam, he is working on his own property. If you believe he is violating HOA rules, you need to pursue that through civil channels. This is harassment. File a complaint with the court." Mike drove away. Patricia stood there staring at my ditch, then at me. I waved. She did not wave back. Over the next few days, the situation escalated. The blocked road meant that the 6 properties beyond the blockage point, including Patricia's house, were effectively trapped. They could not drive in or out. They had to park on the county road and walk the quarter-mile to their houses, or try to navigate through the woods on footpaths. Patricia organized the other trapped residents. She filed an emergency motion with the county court, seeking an injunction to force me to fill in the ditch. The hearing was set for the following week. In the meantime, she tried other tactics. She sent certified letters threatening fines. She posted on the community Facebook page, calling me every name she could think of. She organized a petition. She even tried to have the county declare my ditch a public safety hazard, but the county engineer came out, looked at it, and said it was properly constructed and on private property. The other residents started taking sides. Helen Porter actually called me to apologize, saying she had not realized Patricia would be so extreme about everything. Richard Fletcher remained neutral, but admitted the situation was ridiculous. Susan Fletcher, however, became Patricia's main ally, equally outraged about the inconvenience. The hearing arrived. I showed up with Tom Henderson, my lawyer. Patricia had hired some firm from Wausau, a slick guy in an expensive suit who clearly thought this was beneath him. The judge was a county circuit judge named Martha Kowalski, a no-nonsense woman in her 60s who had been on the bench forever. Patricia's lawyer went first, painting me as a vindictive neighbor deliberately harassing his client. He showed photos of the ditch, diagrams of the blocked road, affidavits from residents about the inconvenience. He argued that my actions were retaliatory and malicious, that I was violating the spirit of the HOA agreement, and that the court should immediately order me to restore access. Then it was Tom's turn. He calmly laid out the timeline. He presented my easement. He showed the HOA bylaws, including the section about property improvements. He presented evidence that I had submitted a request for drainage work, which Patricia had ignored. He presented the original trail access restriction notice. "Your Honor, this is a dispute over property rights. Mr. Sutherland has a deeded easement for access. The HOA violated that easement. My client is simply exercising his right to improve his own property." The fact that this creates an inconvenience for the HOA is not grounds for an injunction. Judge Kowalski listened to everything, reviewed the documents, and leaned back in her chair. Let me see if I understand this. Mrs. Morrison, you moved into this community and decided to ban snowmobile access through common property, despite Mr. Sutherland having used this access for 8 years. It is a nuisance, Your Honor. The noise, the disruption, I understand. And Mr. Sutherland, in response, you dug a ditch that happens to block the only road. I am improving my property drainage, Your Honor. Judge Kowalski looked over her glasses at both of us. This is the most petty dispute I have seen this year, and I have seen some petty disputes. Here is what is going to happen. Mrs. Morrison, I am going to review the HOA bylaws and Mr. Sutherland's easement documents. If I find that the HOA improperly restricted his access, I am going to order you to restore it. Mr. Sutherland, I am going to have the county engineer review your drainage project. If it is genuinely necessary, fine. If it is just you being spiteful, I will order you to fill it in. We are going to reconvene in 2 weeks. Until then, the situation stays as is. Both of you need to grow up. She banged her gavel. We were dismissed. Outside the courthouse, Patricia confronted me. You are ruining people's lives over a toy. You started this. You could end it today by restoring my access. Never. I will fight you until you move away. Then enjoy walking to your house. The next 2 weeks were surreal. The blockage became local news. The Eagle River paper ran a story about the dispute. I gave an interview explaining my side. Patricia gave her own interview, positioning herself as a victim of a hostile neighbor. The comments section was split. Some people sympathized with her noise complaints. Most people, though, understood that you do not move to snowmobile country and try to ban snowmobiles. The winter was settling in hard now. We had gotten 16 inches of snow in one storm, and the temperatures were staying below 20 degrees. Perfect snowmobiling weather. I could hear machines on the trails every day, people enjoying the season. I sat in my house, my own snowmobile winterized in the garage, unable to access the trails I had bought this property for. Patricia kept trying to escalate. She filed additional complaints. She tried to organize a special HOA vote to remove my property from the association entirely, which would have meant I lost access to the shared well system and road maintenance. That attempt failed when Richard and another property owner voted against it, saying it was going too far. Susan Fletcher, however, was all in on Patricia's side. She started a harassment campaign of her own, leaving nasty notes on my property, calling the sheriff to report imaginary violations, spreading rumors in town that I was unstable and dangerous. I ignored most of it, but it was exhausting. Meanwhile, the blocked road was creating real problems. Someone had a medical emergency and the ambulance had to stage at the county road, with EMTs hiking in with equipment. That made headlines. Patricia tried to use it as evidence that I was endangering lives. Tom Henderson countered by pointing out that the HOA could simply restore my trail access, and the blockage would disappear immediately. The county engineer did review my drainage ditch. He interviewed me about the water pooling issue, examined the property topography, and took measurements. His report concluded that while the ditch was perhaps slightly oversized for the drainage issue, it was within reasonable engineering standards and properly constructed on private property. He recommended a culvert be installed to allow road access, but noted that such work would need to be coordinated with the property owner, meaning me. Judge Kowalski's second hearing arrived. This time, she had clearly done her homework. She came out with a written opinion. After reviewing all documentation, I find that Mr. Sutherland's easement for vehicular access is valid and enforceable. Snowmobiles are legally classified as vehicles in Wisconsin. The HOA's restriction on snowmobile use of the access road is a violation of the deeded easement. The HOA is hereby ordered to remove this restriction and allow Mr. Sutherland full access to the trail system through common property. Patricia started to object, but the judge held up her hand. However, Mr. Sutherland's drainage ditch, while technically legal, is creating a public safety concern. I am ordering both parties to work together to install a culvert system that will allow road access while maintaining the drainage function. The cost will be split between Mr. Sutherland and the HOA. This work must be completed within 30 days. She looked at both of us. If either party fails to comply with this order, I will hold them in contempt. Am I clear? We both nodded. Good. Now get out of my courtroom and stop wasting everyone's time. It should have been over. Patricia should have accepted the ruling. We should have worked together to install the culvert and moved on with our lives. But Patricia was not that kind of person. Instead of complying, she filed an appeal. The appeal would take months to process. In the meantime, she argued, the original restriction should stay in place. Her lawyer convinced a different judge to issue a temporary stay on Judge Kowalski's order while the appeal was pending, so we were back to square one. Patricia claimed victory, posting on Facebook about how justice had prevailed. The road remained blocked. My trail access remained banned. We were heading into January peak season and I was stuck. I talked to Tom. Can she really do this? Technically, yes. She is grasping at straws, but the appeal process is her right. It will fail, but it buys her time. How much time? Could be March or April before the appellate court even looks at it. That was the entire season. That was exactly what Patricia wanted. I sat in my house that night, drinking beer and staring at my property maps. There had to be another way. I looked at the trail system maps. I looked at the county forest boundaries. And then I saw it. My property bordered the county forest on the eastern edge. But there was a narrow strip, maybe 50 feet wide, that connected to an old logging road. The logging road was barely maintained, not an official snowmobile trail, but it was there. If I could clear a path from my property to that logging road, I could bypass the HOA access entirely. It would mean cutting through heavy woods. It would mean building essentially a new trail. But it was all on public forest land, which allowed recreational access. I could do it. I called the county forestry department the next morning. I explained my situation to the forester, a guy named Carl who knew me from around town. You want to create a connecting trail from your property line to the old Forest Road 216. Exactly. Is that legal? For foot traffic or snowmobile use, yes, as long as you are not permanently damaging the forest. You would need to mark the route and file a map with us. No mechanized clearing, hand tools only for any brush removal. But yeah, it is allowed. How long would it take to get permission? You just got it. Just file the map and mark your trail with reflectors so people do not get lost. That weekend, I hiked the route with GPS equipment. It was rough going. The terrain was challenging with several steep sections and dense underbrush, but it was doable. About 3/4 of a mile from my property to the old logging road, and from there another 1/4 mile to connect with the main groomed trail system. I spent the next 2 weeks clearing a path. It was hard work, cutting brush with hand saws, marking trees, creating a basic trail. I bought dozens of reflector markers and placed them every 50 feet. I filed my map with the county, making my new trail official. The first time I rode my snowmobile through it, I felt a triumph I cannot describe. The trail was rough, definitely not groomed, but it worked. I had access again. Word spread quickly. Other snowmobilers started using my trail as an alternate route. It became known locally as Sutherland's bypass. People would stop at my house to thank me, to ask about the route, to share their own frustrations with Patricia Morrison and the HOA nonsense. Patricia, of course, was furious. She could not believe I had found a workaround. She tried to complain to the county forestry department, claiming I was damaging public land. Carl came out to inspect, gave me a thumbs up, and told Patricia to stop wasting his time. She tried to get the HOA to declare that I could not access my own backyard from my house, which was insane and went nowhere. She tried to claim that the noise from snowmobiles on the county forest land was still a nuisance. No one cared, but Patricia was not done, not even close. In mid-January, I came home from running errands in town to find one of my fence posts knocked over, and snowmobile tracks cutting across my property where they should not be. It looked like someone had deliberately ridden through my yard, tearing up the snow and knocking over anything in their path. I checked my security camera. I had installed one after Susan Fletcher's harassment campaign started. The footage showed Susan herself, on a snowmobile, deliberately causing damage. She had ridden onto my property, knocked down the fence post, circled around my yard several times leaving deep ruts and rode off. I called the sheriff's department. Deputy Mike came out again, looking tired. Let me guess. HOA stuff. Trespassing and property damage. I showed him the video. Mike watched it, shook his head. That is pretty clear. You want to press charges? Yes. All right. I will bring Susan in for questioning. Susan was charged with criminal trespassing and criminal damage to property. It was not a huge charge, but it was on record. She had to appear in court, pay a fine, and was issued a warning. She blamed me, of course, saying I had provoked her with my illegal trail. But that incident seemed to embolden Patricia. If Susan faced consequences and nothing worse happened, what was stopping them from more direct action? A week later, someone sabotaged my new trail. I discovered it when I went out for a morning ride. Trees had been felled across the path, blocking it completely. Not natural falls. These were deliberate cuts, fresh sawdust still bright against the snow. I hiked the trail. There were 3 trees down, each one carefully positioned to make the trail impassable without major clearing work. It would take hours to remove them. I called Carl at the forestry department. Someone is sabotaging my trail. Trees cut down on purpose. That is destruction of public property. You need to report it to the sheriff. I did. Mike came out again along with another deputy. They documented everything, photographed the stumps, collected evidence. The cuts were clean, done with a chainsaw. Who do you think did this? Mike asked. Who do you think? We need evidence, Frank. Camera footage witnesses something. I did not have proof, but I knew. That night I set up a trail camera along my new route, hidden in the woods with a view of the path. If someone came back to cause more damage, I would have them on video. 3 days later they came back. The trail camera captured everything. 2 figures, faces covered, using a chainsaw to cut down another tree. The footage was not clear enough to identify them definitively, but their builds and movements were familiar. One was Patricia's height and shape. The other was Susan. I brought the footage to Mike. Here is your evidence. Mike studied the video. I can take this to the prosecutor, but defense will argue we cannot prove identification. Faces are covered. Come on, Mike, it is obviously them. I agree, but proving it in court is different. Let me talk to the prosecutor. The county prosecutor was a woman named Jennifer Larson. She reviewed everything, the video footage, the pattern of harassment, the ongoing dispute. She decided to pursue charges of criminal damage to property and disorderly conduct against both Patricia and Susan. The sheriff's department brought them both in for questioning. Patricia immediately lawyered up, refusing to say anything. Susan, however, made the mistake of trying to defend herself without a lawyer present. She admitted to being upset about the trail situation, admitted to having access to a chainsaw, and inadvertently placed herself in the area around the time of the sabotage. The charges stuck. Both women were formally charged, with a court date set for February. The local coverage intensified. This was no longer just an HOA dispute. It was criminal charges, malicious destruction, an escalating feud that was making everyone look bad. The HOA itself became a liability. Richard Fletcher called an emergency meeting and pushed through a vote to remove Patricia as president. She fought it, threatening to sue the other board members, but the vote was 4-1. She was out. Helen Porter was named interim president. Her first act was to formally rescind the snowmobile ban. My access was restored, the original dispute was resolved, and the HOA issued a public apology for the situation. But the criminal case against Patricia and Susan continued. They hired a defense attorney who tried to argue that the sabotage was justified, that I had provoked them, that they were protecting their property values. None of it held water. The trial was in early March. I testified about the timeline of events. Carl from the forestry department testified about the damage to public land. Deputy Mike testified about the investigation. The video footage was played for the jury. Patricia's defense was that she could not be definitively identified in the video. Susan's defense was that she was acting under emotional distress caused by my harassment. The jury deliberated for less than 2 hours. Guilty on all counts. Sentencing came a week later. Judge Kowalski, who seemed to have inherited the entire mess, was not sympathetic. Patricia was sentenced to 6 months in jail, suspended pending completion of 200 hours of community service and payment of restitution for all damage. Susan received a similar sentence with 100 hours of community service. Both women were also ordered to stay away from my property and to cease all contact with me. Protective orders were issued. If they violated the terms, they would serve the jail time. Patricia and Susan left the courthouse in silence. The news coverage was brutal for them. The local paper ran an editorial about how HOAs needed oversight, how petty disputes should not escalate to criminal behavior, and how property owners needed to respect each other. Spring came. The snow melted. I spent the warmer months repairing my property, improving my trail access, and generally enjoying the fact that Patricia was no longer a factor in my life. She kept her head down, completing her community service at the local food bank. Susan did the same, working with the county park system. The HOA under Helen's leadership became what it should have been all along. Minimal, functional, focused only on actual shared maintenance issues. Road repair, well maintenance, basic upkeep. No one tried to regulate anyone's activities. No one tried to enforce lifestyle rules. Richard Fletcher actually apologized to me that summer, saying he should have stood up to Patricia earlier. We ended up becoming friends, riding trails together when winter returned. Helen and I became friendly neighbors, the kind who wave and exchange pleasantries without drama. Patricia Morrison sold her house in August and moved away. I heard she went back to Milwaukee, taking a condo in the suburbs where HOAs have actual power and people tolerate that kind of oversight. She was someone else's problem now. Susan Fletcher stayed, but kept her distance. She and Richard eventually divorced over the whole incident, with Richard keeping the property. Susan moved to Minocqua, and I never heard from her again. When winter returned, I took my snowmobile out on opening day, riding through my restored access road through the HOA common area, connecting to the trails I had bought my property to enjoy. Other riders waved as I passed. The trails were perfect, the weather was cold and clear, and everything was exactly as it should be. My new trail through the county forest remained open as an alternate route, marked on official maps now, used by others when they wanted a more challenging path. It became a small point of pride, a reminder that when someone tries to block your access, you find another way. The ditch on my property remained too, though I did eventually install a culvert at my own expense, allowing road access again. I kept it partly as a conversation piece, partly as a reminder. People still asked about it, and I still told the story of the HOA war, the blocked road, and how Patricia Morrison learned that you cannot bully someone into submission just because you have a title. The whole experience taught me something about HOAs, property rights, and small communities. When people move somewhere new, they bring their expectations with them. Patricia expected suburban order and control. She expected quiet streets and compliant neighbors. She did not understand that rural Wisconsin operates differently, that the culture here values independence and personal freedom over neighborhood conformity. She tried to impose her vision on a place that did not want it, and when that failed, she escalated instead of adapting. The result was criminal charges, humiliation, and eventually retreat. Meanwhile, I am still here on my 15 acres, still riding my snowmobile through trails that have been here longer than any of us, still living the life I moved here to live. The HOA collects its $100 a year for road maintenance and stays out of my business. That is exactly how it should be. Every time I ride past the spot where my ditch used to block the road, I remember that sometimes the best way to fight an unjust rule is not with legal arguments or reasoned debate, but with a simple demonstration of consequences. Patricia wanted to block my access. I blocked hers. She wanted to play power games. I played them better. She wanted to use the system against me. I used it right back. Justice, in the end, was not what the HOA declared or what Patricia demanded. It was what the law actually said, enforced by courts and backed by the rights we all share. Property rights matter. Easements matter. You cannot just decide that your preferences override someone else's legal access. The HOA could have worked with me from the start. We could have discussed noise concerns, established quiet hours, found compromise. Instead, Patricia chose absolutism. She chose control. She chose to start a war she could not win, and I chose to finish it. Looking back now, almost 2 years later, I sometimes wonder if I could have handled things differently. Maybe I could have been more diplomatic, more patient, more willing to work within the system even when the system was being used against me. Maybe I should not have dug that ditch, should not have blocked that road, should not have fought fire with fire. But then, I remember Patricia's face when she closed the door on me that first day. I remember her smug certainty that she could simply decree away my rights. I remember Susan's deliberate vandalism. I remember the appeal that was designed to steal an entire season from me. And I realize I would do it all again exactly the same way. Because sometimes, when someone uses power against you unfairly, the only response is to demonstrate that you have power too. Not to abuse it, not to become the bully yourself, but to show that actions have consequences and that you will not be pushed around. The ditch I dug was not just about drainage. It was about showing Patricia that if she wanted to cut off my access, I could cut off hers. It was about forcing the confrontation into the light, making the conflict visible, refusing to suffer quietly while she used HOA bureaucracy as a weapon. And it worked. Not immediately, not cleanly, but it worked. The court saw through the HOA nonsense. The community sided with common sense over suburban tyranny. The people who broke the law faced consequences. The system, for all its slowness and frustration, eventually produced justice. My life returned to normal. Better than normal, actually, because now everyone knew that Pine Valley Estates was not going to be run by petty dictators. The HOA had been neutered, reduced to its proper role as a minimal maintenance organization. Property owners could live their lives without fear that some busybody would suddenly decide to regulate their hobbies. The whole ordeal became local legend. People still talk about the HOA blockade, the Snowmobile access war, the time Frank Sutherland trapped an entire neighborhood for a season. It has been exaggerated in the retelling, of course, growing more dramatic with each version. But the core truth remains. One man stood up to HOA overreach and won. That matters more than any individual detail. It matters because HOAs across America pull this kind of thing constantly. They make arbitrary rules. They selectively enforce regulations. They use legalese and bureaucracy to bully individual owners who cannot fight back. They count on people being too tired, too broke, or too intimidated to resist. I had the resources to resist. I had property that gave me leverage. I had enough knowledge to find the loopholes. I had enough stubbornness to endure the fight. Not everyone has those advantages. For every story like mine that ends in victory, there are probably dozens where the HOA wins, where people give up their rights because fighting is too hard. That is why I tell this story to anyone who asks. That is why I testified at a state legislative hearing last year about HOA reform laws. That is why I talk to journalists and property rights organizations and anyone else who wants to hear about what happened. HOAs need oversight. They need limits. They need to be prevented from simply inventing restrictions that violate existing property rights. Owners need better protection, clearer recourse, and faster remedies when HOAs abuse their authority. Until those reforms happen, stories like mine will keep occurring. People like Patricia will keep moving into communities and trying to remake them in their own image. And people like me will keep having to fight back, using whatever tools we have available. I am just glad my tools included a narrow road, a good lawyer, and enough property to dig a very strategic ditch. Not everyone gets that lucky these days. When I ride past Patricia's old house, now owned by a young couple from Green Bay who love snowmobiling, I smile. When I use the access road through HOA property without restriction, without complaints, without anyone trying to fine me or ban me or regulate me, I appreciate it. When I see other riders on Sutherland's bypass, using the trail I created when my original access was blocked, I feel satisfied. The land is still here. The trails are still here. The winter is still long and cold and perfect for snowmobiling. And I am still here too, living exactly the life I moved to northern Wisconsin to live, unbothered by HOAs or anyone else. That is victory. That is justice. That is exactly how it should be. And if anyone else reading this is facing down an HOA trying to take away their rights, trying to regulate their enjoyment of their own property, trying to use bureaucracy as a weapon, I have one piece of advice. Know your rights, document everything, find your leverage, and do not back down. The system works slowly and imperfectly, but it does work. Property rights matter. Easements matter. Deeds matter, and sometimes a well-placed ditch matters too.